when we talk about liability concerns, it's not just liability to the regulators, or it's not just liability created by the legislation. There's liability created by the courts. Now, the court system has not dealt a lot with environmental claims. And there's a couple of reasons for that. Obviously, there's the expense of litigation. There's the huge uncertainty. You know, you all, as developers, want certainty in your development. Well, if you come to me and my guys as a litigator and ask me for certainty before I take you to court, you know what kind of answer you're going to get. Very difficult, especially given the tools that the courts have to work with to sort out liability losses. Those of you who aren't familiar, this is one of the so-called leading cases when it comes to the issue of how much do you have to pay as a so-called polluter to the neighbor. When there's no issue in this case that Shell was responsible for contaminating Tridan's property. Tridan was a used car dealership in Ottawa, or maybe a new car dealership in Ottawa, but it was a car dealership, and most of the contamination was underneath the parking lot of the car dealership. And the question turned in that case on how much liability there was in terms of cleanup for the standards. One of the key things to draw out of a case like Tridan, though, is that there are some limits even to civil liability. As we said from the as we said from the compensation principle, the idea is to compensate for the losses that have actually been suffered, but even then the courts will draw limits. And one can take out of a case like Tridan, for example, if you look towards the middle of this, you'll say that, sure, there is responsibility for, quotes, all the damage which is the natural consequence of the escape. There's another restatement of the compensation principle. But then there's this little, of course, they must be reasonable. Of course, says the Court of Appeal, the damages must be reasonable. And, but there's no really elaboration as to what that means. Does that mean, for example, that it's not reasonable to pay someone $200,000 damage for a $100,000 property? We don't know for sure. But clearly the argument is there that damages really have to ultimately be limited somehow in reasonableness. Anytime you see in law a phrase in a statute or in a court decision that uses the word reasonable, or even in a contract, that is effectively a tool that lawyers have to try to limit liability or responsibility into something that ultimately comes down to a judgment call as to what the standard of the day decides is reasonable. Environmental liability can also come across in terms of contracts. And again, there aren't many cases out there, but here's an example of a relatively simple case. Shell Canada had an agreement with a Michael Johnson, who was a former dealer on one of their sites, to clean up Mr. Johnson's site. So there was an agreement, and effectively they delegated responsibility to the consultant Golders to determine the scope and the procedure for the cleanup. Well, as is often the case, and as you've heard a couple of times today, after all this was said and done, there was a discovery of additional contamination, and Mr. Johnson went off to court to get Shell to pay. His argument was, not surprisingly, they're the polluter, and they should pay. There wasn't much contest in terms of the source, but the court said, well, wait a second, even though you can come back and trot out the principle of polluter pays, there is a contract here, and that contract overrides it. And in fact, for that extra contamination, Johnson was required to bear that cost to himself, because that's what the contract did with the risk. So out of this, and certainly in the area of contract, and the most common contract developers will see is in the context of vendors and purchasers, either when you're buying the property or when you're selling it, is that the agreement of purchase and sale can transfer the risk and cost of contamination to the purchaser. It can allocate those costs, and you can draft it broadly enough to cover all the environmental costs that you want. You can say known and unknown, and if the parties agree to that transfer, then the courts will uphold it. And the courts will enforce this, even if the effect is to leave the non-polluting purchaser responsible for what's left behind. So that's the good news about contracts. The bad news, or the problem with contracts, is that it only allocates the risk between the parties to the contract. So if you're a large oil company and you've sold the property to a developer and you've allocated all the risk to the developer and you think that you're done at that point, Well, you're only done as long as that developer is the one who's suing you. Because if that developer in turn subdivides and develops the property, doesn't do it right perhaps, or frankly does it to the standard of the day, sells to a bunch of homeowners who at some point on their watch are faced with a new standard of cleanup, and if their developer is gone, then they may well go back to that original oil company who might still be around. And the same applies in the case of a multi-party developer that keeps developing under the same corporate name over and over again. The contract is only going to allocate the risk as between those two parties. So third parties who might be able to sue in negligence still remain a liability exposure. So even though you've thought you've covered it off with your contract, you've really only narrowed it down to that one area, which is the other side to that contract. So that was civil liability. Then you've got the concept of regulatory liability, which is liability to the state that you have to worry about. We've touched on a little bit on the concept of polluter pays as being one of the key things here, where the regulator, and this has been accepted policy in Ontario for 20, almost 30 years at this point, that given a choice between the polluter and the taxpayer, it should be the polluter that should pay. And by polluter, they mean even somebody who was doing something completely legal 30, 40 years ago. This then evolved into a concept of anybody but the taxpayer should pay in this province. And that's why we now have, or why we've had for several years, the legislation that says anybody effectively with an interest in that land, even if they were just an owner who bought the property and then sold it, never contributed to the contamination. Just because they had an interest in that land and they're still around, if there was a claim by the state can look to them for the cleanup costs as opposed to looking to the state's own resources and the taxpayer. And again, there's an attraction to that politically, and that is a policy decision that governments have made pretty consistently across the country, that it really should be anybody but the taxpayer to pay at the end of the day. And out of that has come the concept of retroactivity, which basically means even after the fact, people can come back and you can be subject to this kind of claim. It has added to it another layer, which is called retrospectivity, which means that even if what you were doing was before the law was passed, you can still be liable. Now, in coming up with these type of regulations, there are certain common themes, and we'll see these consistently across the board, and that is that the remediation rules that determine how clean you have to clean tend to nowadays be tied towards the potential human receptors and potential ecological receptors. Human receptors are affected with your land, are concerned with your land use. What use are you going to make of your land? And if your use is going to include, say, daycare, then that's one issue, and you have to worry about that in terms of cleanup. If your use is going to be commercial industrial, then that's a different level of cleanup. This is as opposed to a version that says we don't care what your land is, it should be clean so that every molecule is taken away. Similarly, the numbers that you'll have to clean up to and that policy developers try to develop are concerned with potential ecological receptors. These really have to do more with the location of your land rather than its use. If your land is next to a sensitive area, next to an open body of water, then that's going to affect the type of cleanup that you need to do to the land. I'm not going to touch on these too much, but in the context of all of that, if that isn't enough, your bank is worried about their liability. The insurance contract is a way of allocating responsibility between you and the insurer. You have to worry about what kind of site information is available to satisfy everybody about this. You have to worry about the perception. Do I really want to live next to a contaminated site, next to a former contaminated site? And there's a whole slew of issues that I'm not going to touch on having to do with the tax structure. Just think in terms of one very simple example of a property that has been held for so long as a brownfield nowadays, labeled as a brownfield, that the current owner, maybe it's a small family, have held this property for decades. And their real concern isn't really selling it or not. Their real concern is when they think about the value of that land, they're also concerned about the amount of capital gains they're going to have to pay to sell it, and it ends up just getting frozen just because of that. You know, it's a relatively simple question, but it ends up freezing a lot of properties in the end. So how have other jurisdictions dealt with some of these themes? And what I'm going to really skim through this in the interest of time. But what I'm going to show you is how several other jurisdictions in really quick ways have dealt with some of these policy issues. And we've got examples in Canada in terms of British Columbia. They have a slightly better system of at least having government sign-off in the end than we do. But the concepts are very similar, right down to even having a concept of retroactivity in their legislation, which is something we see in many other jurisdictions as well. Similarly in provinces such as Alberta.